This is a current trends case brief. The case citation is Barry v. Canada Post and Association of Postal Officials of Canada, 2016, CHRT 1. Miss Barry was an employee of Canada Post Corporation and had filed human rights complaints against both the CPC and her union, the Association of Postal Officers of Canada, in April 2013. On March 26, 2014, pursuant to Section 44 of the Canadian Human Rights Act, the Commission requested the chairperson of the tribunal to institute an inquiry into the complaints. The parties eventually agreed to a voluntary mediation session conducted by a member of the tribunal. At the mediation session, Ms. Barry accepted an offer from the respondents. On January 23, 2015, which was after the 7-day cooling-off period from the mediation session, Ms. Barry advised the parties that she still agreed with the minutes of settlement. Minutes of settlement were prepared and were signed by Ms. Barry and the respondents. Pursuant to Section 48 of the CHRA, copies of the minutes of settlement were forwarded to the CHRC for its approval or rejection. On or about February 9, 2015, Ms. Barry advised the Commission that she had changed her mind and that she no longer approved of the agreement set out in the minutes of settlement. After several meetings between the complainant and the respondents, the Commission proposed to the respondents that they should submit their respective positions as to whether or not the terms of the settlement should be referred to the Commission for approval or rejection, given Ms. Barry's withdrawal of agreement. The respondents rejected the invitation to make submissions and insisted that the minutes of settlement be put before the acting chief commissioner for approval or rejection forthwith. On August 10, 2015, the complainant filed the present motion. The present motion is filed by Barbara Barry, seeking an order to reopen 2 complaints that were before the tribunal. In the motion, she requests that the tribunal find that the settlement should be considered null and void in light of the circumstances surrounding its negotiation, which are outlined in her motion, and that the case proceed to inquiry. Issues. Does the tribunal have jurisdiction to decide a dispute relating to the validity of a settlement agreement that has been approved by the Commission under Section 48 of the CHRA? If the tribunal does have jurisdiction, has Ms. Barry shown that the minutes of settlement should be considered null and void on the grounds that, according to her submissions, she was under duress, the respondents misrepresented the facts and mediated in bad faith, and she advised the other parties that she had changed her mind just 23 days after the minutes of settlement were signed. Decision. The tribunal dismissed the motion to reopen the case. Rationale. The tribunal found that it lacked jurisdiction based on the tribunal's recent decision in Cosson v. Air Canada 2015 CHRT 17 and Powell v. United Parcel Service Canada Limited 2008 CHRT 43. Ms. Barry has not alleged any facts in support of her general assertion that she was being compelled to act against her will at the mediation. Ms. Barry benefited from a 7-day period during which she was able to reflect upon her decision to settle at the mediation session. Ms. Barry alleges that the respondents did not tell her the whole truth at the mediation session. This argument fails because Ms. Barry does not claim that the alleged misinformation was actually conveyed to her by the respondents. One of the imperative assurances of a mediated settlement is finality. The 7-day cooling-off period was made clear to the parties, and Ms. Barry does not dispute that. If the tribunal were to set aside the preemptory nature of the 7-day cooling-off period on the grounds invoked in this one case, the integrity of its entire mediation process would be brought into question. The decision of the court was stare decisis, referencing several cases as stated previously. The decision of the court was also based on considerations of fairness, as stated previously in the rationale section. Analysis. This case is significant and will most likely relate to and be referenced by other cases brought to the court because of the issues of jurisdiction of the tribunal and of the issue of contractual nullity due to duress, misrepresentation, bad faith, and prompt withdrawal of consent. Survey question. Do you agree with the tribunal regarding its decision to dismiss the motion?